Well, hello, everyone. Thank you for tuning in today. Welcome to the Time for More Injury Funding podcast for all who want to learn about legal funding and its significance in personal injury, workers' compensation, medical malpractice, civil litigation, dog bites, and all other types of law practice domains. I'm your host, Laura, founder and CEO of More Injury Funding, the legal funding counselors with passion for law, medicine, legal funding, and heart for all suffering individuals. More Injury Funding is a sponsor, member, associate board member, or business partner of this podcast, Georgia Trial Lawyers Association, Academy of Truck Accident Attorneys, Georgia Association for Women Lawyers, or GAL, Sandy Springs Bar Association, Georgia Association of Paralegals, Atlanta Legal Aid Society, State Bar of Georgia, St. Andrew Rowing Club, and Georgia Hispanic Chamber of Commerce. In today's episode, I have a very special guest with me today, personal injury attorney Alex Seay with Bird Law Group based in Atlanta, Georgia. Alex comes from a family of doctors, teachers, engineers, but no lawyers in the immediate relative group. Several immediate relatives, however, are medical doctors, and this is how she got to where she is today. And that's how that experience with doctors and her family growing up shaped and influenced her to be a medical malpractice lawyer today. And we will dive deep into decoding the legal puzzle, the process of intake and affidavit requirements in med-mal cases, medical malpractice cases. At the end of our episode, I'll have a fun pop-up question, so stay tuned then. Welcome to the Time for More Injury Funding podcast, Alex.
Thank you. Thanks so much for having me today. I really appreciate it.
Absolutely. So please tell us a little bit about Bird Law Group and how did you become part of it?
So Bird Law Group is primarily a medical malpractice law firm here in Atlanta. We handle, I would say, about 85 to 90% medical malpractice cases, other catastrophic injury and wrongful death cases as well. I was a 2L, second year at Georgia Law School, and I was hired by Bill to work there for the summer. Bill Bird, so the firm's namesake, and we always used to joke, well, we hired Alex and then she just never left.
I love it.
But really, the reality of it is I was fortunate enough that Bill offered me a full-time position after my summer internship. And when he retired in 2020, I took over the firm and have been running with it ever since.
And how long it's been?
October 1st of 2020 was day one after the transition of the firm.
That's amazing. So what types of cases you kind of, basically, touched there for a second, but what types of cases do you handle at Bird Law Group?
Mostly medical negligence cases. So any type of injury from a medical negligence or an act of medical negligence, whether that be an ongoing injury, paralysis after a surgery, or wrongful death, and then any other wrongful death or catastrophic injury cases that deal in the area of liability. But like I said, about 85 to 90% of those are medical in nature.
Mm-hmm. And what is a typical process for intake in a medical malpractice case? And how does it differ from any other types of personal injury cases?
So for a medical malpractice case, we have to get really detailed in that intake process. These cases are very difficult, if I'm being transparent and honest. Some of the hardest cases that I've had experience to work on, but it's what I truly found my passion to be in. So here I am. But we have to get very detailed. We need to know so if the person's calling in for themselves or for another, we need to know about any pre-existing conditions. We need to know about the current health and status of the person that was injured. And then we need to know where they were being treated, what they were being treated for, generally what the caller believes was the issue that led to the injury or to the death. And then from there, we take our intake, we take our facts, and obviously very importantly is when did it happen? Because you only have 2 years from the date of injury to bring a medical negligence case generally in Georgia. So we take those facts that we get from that initial intake phone call, and we do our own sort of, I'll call it pre-investigation, because in order to file a medical negligence suit in Georgia, you have to file it alongside a professional affidavit from a medical doctor or a provider that has experience in the area or with the type of procedure that you are alleging was done improperly. So it's sort of a stamp of approval to get your foot in the door, which is unlike any other case that you can file. I mean, you have a personal injury case as a result of a car wreck. You just file the complaint. You allege your facts as your clients tell you, and you file the complaint. But we've got to go out to experts, so medical doctors, pay them for their time, pay them for their review, and you don't know if they're going to say yes or no. So from a perspective of trying to make sure we're taking good cases and the right cases, we've developed a process where we get all those facts and then we do our initial investigation. And whether that's talking to experts that we work with frequently, who we can kind of what I call curbside cases with before doing an actual review or an official review, or going through medical journal articles. Over the course of the decade or so that I've been doing this, you become very familiar with medical terminology and different types of medical procedures. So we use that familiarity and relationships we have with experts we work with frequently to help us with that initial investigation.
Wonderful. Can you, Alex, explain the affidavit requirements in medical malpractice cases? What purpose does it serve, and what information should be included in the affidavit?
So the medical affidavit requirement serves the purpose, purportedly, to prevent frivolous lawsuits from getting filed. Because, the intricacies of medical negligence or medical mistakes, it's really detailed. And in order to make sure that, in order to try to prevent, I guess, frivolous lawsuits from being filed, this extra step was put in for these types of cases, so that you have to have a medical doctor, medical provider saying, yes, here is at least one allegation of negligence that I swear to under oath in this affidavit that happened, giving validity to the complaint. Now, you don't have to allege every allegation of negligence, and that makes sense because we have to go through the discovery process. And typically, if not always, you find additional issues as you go through discovery and find out more about what happened. But you just have to allege at least one allegation of negligence in the affidavit to get your foot in the door.
It's very interesting. So, Alex, what are some common hurdles that plaintiffs typically face during the intake process in the usual medical malpractice case?
Getting their medical records. I mean, it is, and it still surprises me. But it is unbelievable how difficult it can be with some providers out there to get a certified copy, or screw the certification, just to get a copy of the medical records. And that's even if our clients are requesting them themselves. Now, I'll give it to some of the bigger institutions. They have made it easier and more accessible for patients recently. They can get online and do it just by uploading a copy of their driver's license. But man, I mean, just recently we had a client who had to put in 5 different requests for his medical records.
That's painful.
5. And then there's a box sitting right over there in the front of our office where we requested medical records for a client, and we requested them on a CD so that we could, try to mitigate the costs. They don't have to print all of them out for us. Well, they decided to print them anyway and send us a $5,000 invoice for medical records.
Unbelievable. Without your permission, probably, without your knowledge.
Absolutely. In fact, completely against our express instruction that if the cost was going to be more than $50 to reach out to us. And they just decided not to do it.
Terrible, terrible. So make sure you get your records if you're in a situation like that.
Yes. And we've actually developed a system where we kind of have a step-by-step instruction that we will send to the clients to help guide them through the process for the places that are more difficult to get them. Because a lot of times it's not as easy as walking in and walking up to a desk and saying, here's my ID. I was a patient here. I'd like my records. It should be, but it's not always.
You would think. So, Alex, how does the involvement of expert witnesses impact the outcome of a medical injury case?
I think it is the testimony from the experts, typically in those difficult cases that we have. And honestly, it's the difficult cases that end up going to trial, right? The good ones usually resolve. Sometimes they let us take our good ones to trial, and we enjoy those opportunities. But the involvement of the expert witnesses, if you're handling it correctly, they're the ones who are going to take the stand and explain the medical difficulties, or at least give you credibility to explain the medical difficulties and details to a jury in the case. So I think they're there to translate, right? If you've got a good expert, they're really translating what the medicine is in a case. And then the jury is going to decide, oftentimes it becomes what we call a battle of the experts. So they're going to decide whether they believe our experts or the other side's experts.
How long does a typical medical malpractice case take on average statistically?
Well,
if there's such a statistic at all.
Yeah. So from our perspective, especially after COVID, and I can't believe we're still talking about that 4 years later, the backlog that the shutdown caused, but we are. We've got a case where the negligence happened in 2019, and we are going to trial in July. So I mean, that's looking at what, 5 years
plus.
And yeah, so usually what I tell my clients is, anywhere from 2 to 5 years is what to expect. We have another that we investigated and ended up resolving pre-suit within 6 months. So, you can be on the other end of that too, but we like to exceed expectations, right? Not fall below them. So I always give that longer estimate.
And what specific qualifications do these medical experts need to have?
So it's really case dependent, and it's specific to the facts of the case. You need to have been practicing in order to testify on what we call the standard of care, which is the standard by which to determine if a provider was negligent or didn't exercise due care. You need to have at least 3 of the 5 years prior to the injury of active practice in that area of medicine, performing that procedure that's at issue.
Very interesting. Alex, can you provide some examples of situations where expert witnesses played a crucial role in providing medical malpractice or defending against such claims?
Yeah, and honestly, our experts play a great role in every single one of our cases, and they're critical to proving our case. But where I've seen the testimony from doctors really have an influence on a jury is if it's treating physicians. So if you've got, let's say, someone who went in and there was a diagnosis that was missed, and then they were seen at a later date by another physician. And if that treating physician who saw them at the later date comes in and says, well, yeah, I saw them and they had this condition and it should have been diagnosed, a year earlier. Having those later physicians who actually saw the patient, right, saw your client, having their testimony, I've found juries put more weight into that, because these are physicians who actually laid eyes on the patient, on the client, and they don't have nobody really has skin in the game. But from a jury's perspective, they're not being paid for their time and they weren't engaged as an expert. So I found that having treating physician testimony can really change the scales.
What factors do typically play a role when selecting an expert witness for your cases? How do you ensure that the chosen expert has credibility and expertise in the relevant field?
So we do a lot of research. There are different companies out there who will help you find experts. We have used some of them before, but I find the most reliable way for me to find an expert that I truly believe in, that I trust. Sometimes it's through one of those third-party companies, and they've been very helpful when you need someone in a very specific area, right? But for us, I like to do it myself. I like to do it in-house. And what we'll do is we'll go and we'll search a particular condition or issue, and we'll see who's been published on it. If you've written an article about it, you've done a research study about it, you're probably going to be someone I want to talk to about it. Or someone that the defense is going to try to talk to, right? So it's going out and seeing who's really made a name for themselves in a certain field and finding that expert. I know there's some folks, and I've probably been guilty of this too, is you also like to see if you can find experts that are from recognizable institutions, right? So if I'm bringing someone down from Harvard or Johns Hopkins or Yale, juries may not know anything about medicine, but they sure as hell know what Johns Hopkins is or Yale or Harvard, right? That doesn't play as much of a role as being experienced in a certain area does, but I'd be lying to say if it wasn't a consideration.
Are there any specific rules or guidelines regarding this testimony provided by expert witnesses in medical malpractice cases?
Yeah, so their testimony, generally, the courts play the role of what we call the gatekeeper on expert witness testimony. And they're supposed to be pretty lenient about what they let in up to a certain threshold. And it has to be reliable. They have to have the requisite education, qualifications, expertise, and then based on reliable principles and methods. And it has to be relevant, right? It has to be helpful, is what our Supreme Court has said to the jury. So ideally, they're not supposed to come in, the experts, and talk about their own personal opinions. They're not supposed to come in and talk about a condition that they've never diagnosed or treated. And they're not supposed to come in and talk about something that is wholly unrelated to the patient's medical history, right? You can't just make something up. And it has to be to a reasonable degree of medical probability or certainty. But generally, what we found is oftentimes if there's an issue with expert testimony, barring some of the blatant cases where it can be excluded, the courts will generally leave it up to cross-examination so that we can cross the experts on what we see as the deficiencies in their opinions and then let the jury decide.
How do defense attorneys typically challenge the credibility or qualifications of expert witnesses presented by the plaintiff's attorney like yourself in the medical malpractice case?
So they will, I will answer this with an example because it comes to mind as I think about this issue. One of the first trials I ever worked on with the firm was actually in Alabama. And I remember being there in the courtroom. I wasn't first or second chair. I was brand new baby attorney. So I was sitting there, watching, helping, involved in the prep, kind of boots on the ground in the trenches every night as we were getting ready for the next day in court. And we were prepping an expert. And, I went to bed thinking, man, this guy's really going to give it to him tomorrow. It really is. So we get in there and he does we do our direct examination of him. Testimony is lovely. It came out perfect, just as we had discussed based on the facts. It all made sense. And then the defense attorney stands up and he slaps down like 4 different bound copies of things on a desk. They were prior depositions of this expert. So this defense attorney had, to his credit, and still irks me to give him any credit, had gone and done a bunch of research, and they'll go and pull prior deposition transcripts. And where this becomes problematic is if you've got an expert witness who's testified a ton, which can be a good thing, right? They're comfortable with the process. They are obviously, they have expertise in the field. But I think it gets to a point where you got to be careful, right? Because you got to make sure the testimony is consistent. And that's one of the most effective ways that I've seen a defense attorney challenge an expert's credibility is, well, you testified in this case and you were under oath in that one, just like you are here. And you said X, but today you're telling this jury Y. What do you make of that? And I don't know if anybody's found a good answer to that, let me know. But barring a distinguishing fact, that wasn't helpful.
What happens if there is a disagreement between the opinions of the plaintiff's expert witness and that of the defendant? How is this resolved during the legal process?
The jury. Quite often, our experts on both sides may have some overlap in what they think, right? There may be some pieces of the opinion that touch on each other, overlap. They agree on some things, but every time you go to trial, there's going to be a disagreement, and typically that's for the jury to resolve.
And as we, Alex, nearing the end of our podcast episode, can you tell us, please, what have you found to be helpful in preparation for your case when it comes to expert witness testimonies?
So one of the main things that we try to do, and you can't say it too much, honestly, in my experience, to a doctor, is you have to speak plain English, right? The example I give my experts sometimes is it's a heart attack, not a myocardial infarction, right? Juries, you need to speak jury. You need to speak non-doctor person or non-doctor language people. And then the other part is really using focus groups. There's a lot of different companies out there that offer the opportunity to focus certain issues of your cases. And I found that to be really helpful because you can present an issue, see how people react to it. And ideally, these people are reflective of the people that you're going to have on your jury. And then you tailor your presentation of the case to make sure that you're explaining it the right way and that it's being received the way you want it to be received. Ideally, we live these cases for so long. And we have it in our heads and can say it a certain way. And we're like, yeah, we know exactly what we mean. It's, you can confirm that you've said it the right way. But it's really important not to lose sight of the fact that when you're in trial, you're presenting the facts of your case to 12 people who have never heard anything about your case before. So the focus groups I found very helpful to take some of the very complex, difficult issues that we have in our cases and help us tailor them and put them in a way that we hope, properly handled, the jury understands.
Is there any particular number of focus groups that you would recommend based on your personal experience for one particular case? Is it 1, 2, 3?
No specific number, but I would definitely say that if you start earlier in your case and maybe focus different issues during discovery, that you'll find that doing multiple focus groups is actually helpful. I think a lot of people, and I've done this too, you wait till the end, right? You focus it before you go to trial. But I think, and I've heard from colleagues that it can be, and from my experience, helpful doing it earlier so you can be working your case up for trial and honing the way you're going to present your case as you're doing discovery.
Mm-hmm. Again, thank you so much, Alex, for being my very special guest on my podcast. It's time for more injury funding today. I hope it was informative and educational for everybody. And as promised, I have one last fun pop-up question. You ready, Alex?
I don't know. All right, we'll see.
What book, movie, or a TV show has had the biggest impact on your life or influenced your perspective on your work?
Okay, well, I feel like I'm supposed to name some classic, right? Or an influential, very serious movie or book, but I'm going to be real honest and real transparent. When I go to watch TV or read a book, it's usually not very serious because what we do is so serious, right? You're on and it's serious and it is intense stuff. And I love everything about it. But when I'm watching TV for entertainment or reading a book for entertainment, it's usually like slapstick comedy, like Step Brothers.
You're kind just like me. I'm exactly the same way. When it comes to relaxation, I'm totally off limits there.
Yeah. I mean, I can't say that Step Brothers has influenced my life or, well, maybe it has, because I mean, there's always constant jokes in my household coming from that movie, or you can probably catch me watching cartoons with my daughter.
Aww.
I just got her into Scooby-Doo.
Oh, my goodness.
The OG Scooby-Doo.
Oh, the real one.
Yeah, not the new digital animation one. No, the real one.
It's the best one.
Yeah.
I've missed those years. My son's almost 17, so I missed those good years. What about Tom and Jerry?
We haven't gotten into Tom and Jerry yet, but or the one with the Roadrunner.
Mm-hmm.
Yeah. Yeah, but we'll bust those out. We're Scooby-Doo and the Smurfs right now are at the top of the list, and it's a cartoon that I can watch with her, as opposed to some of like the YouTube kids shows she wants to watch. So I'm really trying to move it towards the
old top of that. Yes, I love it. Absolutely. Yes. So now, if anybody is looking for you or for your law firm, how can they find you? Do you have a website, social media resources, email address, phone numbers?
Yes. We have a website and we have social media. You can find us on Facebook. You can find us on Instagram. Our website is birdlawgroup.com. And we are Bird Law Trial Group on Instagram and Facebook.
Wonderful. Thank you so much again. I was Alex Seay with Bird Law Group based in Atlanta, Georgia. I want to thank you all for watching and listening to our episode today. For more tips and tricks on legal funding and personal injury related topics, follow me, download, like, and subscribe on the It's Time for More Injury Funding podcast. And also go to my website at More Injury Funding. So I want to thank you all for listening and watching our episode today. For more tips and tricks on legal funding and personal injury related topics, follow me, download, like, and subscribe for It's Time for More Injury Funding podcast on Spotify, Amazon Music, Apple Podcasts, iHeart, and all others worldwide. And follow More Injury Funding on LinkedIn, Instagram, TikTok, Twitter, Pinterest, YouTube, Google business profile, and my website at moreinjuryfunding.com, more with 2 O's. I want to thank you all. Until then, be well.
Thank you.